Hello and welcome to the webinar on more practical HR guidance for employers. My name is Nathan Sanderson. I'm the Executive Director of the South Dakota Retailers Association. We're pleased to be joined once again by Chris Hoyme. Chris Hoyme is an attorney with the Jackson Lewis Law Firm in Omaha, Nebraska. And Jackson Lewis has a retainer agreement with the South Dakota Retailers Association that allows our members to get some basic labor law answers free of charge, and he's been just fantastic over the last several weeks as we have been navigating the response to COVID-19. A couple of quick pieces of information before we begin. First, this webinar is being recorded like all of our other webinars have been. We will send out an email after the recording is over. Now, it might take a little while, up to a few hours, to get the presentation formatted and uploaded, but we guarantee you that we will get that emailed out to the attendees and to our members as well. It will also be available from the COVID-19 page or series of pages that are available at sdra.org. That's the Retailers Association website. We've got a number of people signed up for this webinar, right around 100. And so we will take some questions, but the majority of Chris's presentation today is going to be answering questions that have previously been submitted. So with that, we'll jump right into it. Thanks, Chris, for joining us yet again and providing us a bit more information on employment issues in response to COVID-19.
Thank you very much, Nathan. And again, it's our privilege at Jackson Lewis to be able to work with the South Dakota retailers to provide this service, especially in this time of crisis in regard to employment issues that we are seeing with COVID. This is a relationship that has exceeded 10 years. And as I have talked with members and emailed with members over the last 3 weeks regarding these issues, I just want all of you to know that are listening that we are doing our best, all of us at the SDRA, to get your questions answered, get information out to you, hopefully get advice out in a practical way that you can use. If for some reason we haven't got back to you, I apologize for that. We're doing our best, and we will continue to work all the hours necessary because you are the ones that need our help right now, and that's the name of the game. Today, similar to what we did a couple of weeks ago, we're going to discuss various HR issues related to COVID. You have submitted a number of questions that I will attempt to answer as we progress, and then we'll see what we have left for additional questions. But remember, as Nathan said, the SDRA has an excellent COVID page that has a variety of resources on it from a variety of different sources, including webinars, for example, not only from Jackson Lewis, but from the South Dakota Department of Labor on unemployment, from the National Federation of Retailers. An excellent webinar was done on Sunday for those of you that are getting paycheck protection loans or investigating them. That was excellent. There's all kinds of great resources that really may answer your question without having to seek additional help through the retainer or any other source. Now, remember, Jackson Lewis also has an excellent resource page, as I've indicated on this slide. It has real-time state and federal charts regarding COVID developments, and it has a daily briefing that you can sign up for free. Usually they're only 15 or 20 minutes that hit various employment issues that our clients are seeing. It's free of charge. There's not going to be any solicitation. We just are trying to get information out to all of our clients as we progress. Okay, what are we going to try to cover today? We're going to cover some questions that are fairly common in terms of COVID-19 in the workplace. We're going to look at recent EEOC guidance on what we can and cannot do in light of COVID. We're going to talk about furloughs and reduction in force, pay reductions and changes. We're going to look at the Families First Coronavirus Response Act, FFCRA. We're going to look at the Emergency Paid Sick Leave Act, all these acronyms, EPSLA, Emergency Family and Medical Expansion Leave Act, EFLEA, and we're going to look at the CARES Act and different ways to get loans and support and grants and relief there. So we have a variety of topics intertwined with the questions that you have submitted. And first, let's talk about some common questions that we see in the workplace specifically. And this comes from recent EEOC guidance. What can you do if an employee is showing symptoms of COVID-19? You submitted a number of questions prior to this webinar specifically on this point. If I have an employee, a customer, a vendor, whatever, that is showing symptoms of COVID-19, what are my options? In regard to an employee, we may ask if they are experiencing flu-like symptoms. We may send the employee home if they display influenza-like symptoms. We may and should encourage them to telework. We may ask if they have been tested for COVID. We may require infection control practices and should, such as regular hand washing, etc., sneezing etiquette, coughing etiquette. We may require them to wear personal protective equipment, PPE. We must maintain all, in doing this, we must maintain all medical information as confidential, as we always would. We cannot specifically ask employees to disclose any medical condition which makes the employee vulnerable. We can't say, do you have diabetes, for example? Do you have whatever it may be? But we certainly can ask them if they have collateral medical conditions which may be exacerbated, they should let us know without getting into the specifics of the condition. What do we do if an employee tests positive for COVID? The CDC recommends that employees who have been diagnosed with COVID-19 and have had close contact with individuals confirmed to have COVID notify human resources. We should have a policy and practice to that effect. We should keep that employee out of work for 14 days if asymptomatic, or until he or she is certified, medically certified, as being free from the illness and no longer contagious. We need to identify those employees who have had close contact while working and notify them without disclosing the name of the employee that an employee is tested positive and they may have had close contact with the individual. We have had questions come up with, what are my obligations in regard to a positive test? And we think clearly the best practice and the advice we give is to notify employees that they may have been exposed to COVID if they've been in close contact, and they should get tested, take appropriate action. Likewise, as we continue what to do if an employee tests positive, direct the employees determined to have had close contact to remain out of work for 14 days. Depending on the nature of the infected employee's presence in the workplace, consider the need to temporarily close the workplace if it's a small area while cleaning efforts are undertaken. And I was talking to a number of members throughout this week about our obligations and need to deeply sanitize if we have an employee who has a positive test, okay? Now, the CDC on this next slide has set forth what I think is a very helpful and valuable protocol and criteria for return to work. The bottom line here is if it's test-based, you get 2 consecutive swab specimens showing, and this comes from doctors, we're not doing this ourselves, this comes from medical professionals taken 24 hours apart showing they are no longer positive, or in the non-test-based strategy, we allow time to pass that's asymptomatic, and we always are allowed to and should seek a medical opinion indicating that employee is free to return to work. Now, we get a lot of questions, well, what if I have an employee who cannot come to work for whatever reason, usually it's COVID related, do I have to pay them? If they are a non-exempt hourly employee, there's no federal law that says you do. However, says the lawyer, and there are a lot of howevers lately, is that federal or state wage laws may require exempt employees, and we're talking exempt employees, to be paid if, for example, during the week you have a salaried employee who suddenly cannot come to work, in this case for a COVID-related reason, they would have to be paid the salary for that whole week. And most importantly, there are state and local laws and the Families First Act that we're discussing that may require paid sick leave that would be applicable here to symptomatic employees, and we will discuss that in much detail. So in regard to, I just want to emphasize, if you have exempt employees, salaried employees, it's very important that we understand that if they start the week and then they can't work the remainder of the week for a COVID-related reason, a lack of work-related reason, in all likelihood, generally, they need to be paid their full salary for the week. Another question that we see regularly and saw in preparation for this webinar is, can an employer require an employee to come to work at the office? And the answer is, in most states, if that employee's duties cannot be performed at home and the company is on an essential service list, i.e., you are open for business, then the employer can require attendance and is recommended to follow social distancing and CDC good hygiene practices like we've already discussed. So yes, unless you are prohibited by order, state or federal, from having your business open, and you have an employee that is not symptomatic and doesn't fall in the criteria that we'll discuss momentarily regarding paid leave, you absolutely can require them to come to work. Remember, we may get into instances, and we'll discuss this also because it's a regular question, where an employee will say, well, I don't think it's safe, and maybe we have an OSHA issue, or an employee refuses to come to work saying, I just don't feel comfortable. And we decide we need them to be working, and in essence, they are refusing to work, that we could have some wrongful discharge risks, some OSHA compliance risks. But understand, absent their concern about working being supported by a medical or mental health professional, simple unsupported anxiety about returning to the workplace, even in situations that we're in now, is not a ground for the employee to refuse to work. Now, practically, do we want to fire someone who says, I'm scared to come to work? Generally, we do not. We will look for options, alternatives, to hopefully persuade that employee to come to work when they hear all the safe hygiene practices, cleanliness practices, social distancing practices that we are requiring. But we really don't want to get into a situation, if we can avoid it, where we would fire someone, terminate their employment in this context. And I would advise, before anyone believes they need to fire someone for a COVID-related reason or in a situation involving COVID, seek professional advice because the risk can be high. But if they're simply saying, I don't want to come to work, I'm anxious, I don't know what'll happen, generally that alone is not enough and they need to come to work. Okay, what does the EEOC say about all of this? Let's look at some scenarios that the EEOC has addressed. And we saw in your questions, the company is taking temperature of all employees as they enter the workplace. Don refuses to allow his temperature to be taken. May the employer bar Don from the workplace if he refuses. In essence, we are saying that as a term and condition of working at our place of employment, you've got to have your temperature taken, Don. And if Don says, I don't want to, I don't like my temperature being taken, what does the EEOC say in terms of your legal rights? The EEOC says, yes, under the circumstances that exist today, the COVID safety concerns, the ADA, the Americans with Disabilities Act, allows an employer to bar an employee from physical presence in the workplace if he refuses to have his temperature taken, or, and this is a significant or in my opinion, to answer questions about whether he has COVID-19, has symptoms associated with COVID-19, or has been tested for COVID-19. Now, as this best practice bullet suggests, we're not trying to have a showdown at the OK Corral with our employees over this. We value employees, especially until recently. South Dakota had one of the lowest unemployment rates in the country. We value our employees, and hopefully there's a way through practical education and indicating to the refusing employee why it's important from a safety perspective that they test or disclose information about whether they have COVID or whether they are symptomatic of COVID, that they understand our rationale and agree to it. But nonetheless, we do have that right, and in most instances should be exercising that right. Okay? Now, next workplace scenario, as we've seen from the EEOC guidance. The company provides essential services. So even if you're in Minnehaha County under the governor's new order, but you are a business that is within the definition of essential service and therefore is continuing operations, Harriet and HR, in spite of all this, would like to require all employees over the age of 65 to take leave for their own health and safety to decrease the possible exposure to COVID-19. Because the order in place now says, unless you're essential, if you're 65 or older, you need to be at home. But let's say we are essential and we have a well-intentioned HR director who said, you know, I think everybody over 65 should stay home. Can we require that? And the answer would be, no, this could be evidence of age discrimination because we are not requiring all workers. It would only apply to those over 65. Now, in the practical real world, employees over 65 in an essential business clearly are still within the high risk category as defined by the CDC. And if there is a way that they could work at home, that would be great. And if there is a way, should they choose voluntarily to take leave, I believe there could be some common ground there that would allow a positive solution so that their desire not to work or their desire to work at home so as not to be exposed in the workplace could be accommodated. Okay? Number 3, Leonard, who is 66, is asked to work remotely because he is at higher risk of experiencing severe symptoms of COVID because of his age. No other company employees are working remotely. Must the company grant Leonard's request? And the answer is no, we don't have to. However, if we are allowing any comparable worker, if they're able to do work at home, to telework, we're allowing them to do that, okay? Now, the EEOC has been very clear, and much of this could be considered before COVID to be violative of the ADA, but now, due to the safety crisis, the EEOC has indicated it is not. It is okay to take a temperature screen, but the medical information must be kept confidential. Remember this, though, a temperature alone, a fever alone, is not always determinative of COVID. Perhaps you, as an employer, should hire a contract nurse to take the temperature of all these people and track the data in a professional way. It is okay to inquire about symptoms. It is okay to bar symptomatic employees from the workplace. It is okay to screen applicants for COVID-19 after making a conditional job offer. It is okay to delay the start of an applicant who has COVID or related symptoms. It is okay to withdraw a job offer if the start date is immediate and the applicant has COVID related symptoms. Likewise, looking at some of your questions, can I require an employee to have their temperature taken when they arrive at work each day? Yes. And send them home if they're running a high temp? Yes, because that is a symptom of COVID-19. What do I do if I think an employee may have coronavirus or if I think they may have been exposed? Well, it would depend on whether they are symptomatic with COVID-related symptoms, high fever, cough, consistent sneezing, whatever it may be. If it's based on those symptoms, yes, you may require them to go home, okay? This last question was, if I think an employee has COVID-19, is there someone I should call, or is that up to the employee? And the answer is, if I have an employee who is symptomatic, I would address to them that they go home, and I would direct them to their physician, or I would direct them to the county board of health. If I have an employee that indicates to me they have tested positive for COVID, we are advising employers to contact the Board of Health and indicate that an employee has told us they are COVID positive. In most cases, just to be even more safe, we advise employers to seek the consent of that employee to notify the Board of Health in that individual circumstance. Okay? Now, next slide, next topic is implementing pay changes, furloughs, and reductions in force, which the great majority of you have been faced with and challenged with in light of this COVID crisis. So, what do? We're faced with a situation where our business, in all likelihood, hopefully for a short period of time, is going to face a significant downturn until folks are allowed in some form to get back out there and restart the economy in whatever business we're in. Obviously, we need to get a plan, evaluate our financial condition, determine what kind of message we want to send in terms of complying with CDC guidance. We want to familiarize ourselves with executive orders and regulation. If you're union, you want to determine whether there's a collective bargaining agreement that we need to be compliant with. What are our options? Our options are we going to reassign employees to areas of more critical concern? Are we going to reduce wages and salaries? Are we going to reduce hours of work? Are we going to furlough, i.e. temporary layoff, temporary leave for a short period of time, usually 10 weeks or less? Or are we going to do reductions in force terminations across the board? I can tell you, and this will answer a number of questions that we've gotten in preparation for this webinar and that we receive from all of you on a daily basis, is most employers that are members of the SDRA are taking the furlough approach, temporarily laying folks off for 10 weeks or less, and then hopefully calling them back as business allows in a fairly short period of time. At least that is the hope. Also, and we'll talk about this in terms of situations where those of you have sought paycheck protection loans, our obligation to hire people back and get our payroll full-time equivalent numbers similar to what they were before the COVID crisis will allow us to forgive, as we'll work through later, a significant portion of the loan. So those are our options, okay? And it's important that we evaluate each one. As we go through our options, make sure we consider what are our wage and hour restrictions and risks. Non-exempt employees, if as I've already indicated, if we have somebody who's on a salary and they work 2 days and then we say, hey, we're going to have to furlough you or lay you off, in all likelihood, you're going to be responsible for that whole week. Non-exempt employees, you probably would not be because they are hourly. We have to review, and we will in a short period of time here in the next couple of slides, look at what unemployment benefits are available to those that we would either wholly or partially lay off. And remember this, as we're evaluating furloughs versus terminations, generally benefits stay intact during a furlough, 10 weeks or less, meaning health insurance, etc. You would need to verify that with your health provider in this case, but usually they do. Benefits do not stay in place if we are terminating and have no right to recall. We're not furloughing, but we're terminating employees, and therefore we would have COBRA obligations to notify the employee that we're not providing insurance, and if they want to pick it up, they'd have to pay, generally at a very high premium price, COBRA. So as we analyze whether to furlough or terminate, remember, benefits generally stay intact during the furlough situation as opposed to the termination, okay? Okay, what are our wage and hour issues that we need to consider? We've already talked about the first one. The second one, and this has come up a lot, and we've seen it in our questions today, and what we've seen regularly from members calling in on the retainer. And as a quick aside, Nathan and I were talking before we started. I bet I have talked to personally or emailed with over 300 different members over probably 600 or 700 different communications in the last 3 weeks over COVID issues. So you're using the retainer, that's great. But this is a common question. Many times an employer will say, okay, I want to reduce salaries. I want to keep people working, but I want to reduce salaries. Remember, we cannot reduce our salaries beyond the minimum threshold, $684 per week, $35,568 per year, without losing that exemption. Why do we want the exemption? If I have a salaried employee and they qualify through all the criteria set forth in the DOL, we don't have to pay them overtime. But if we bring them underneath that minimum, $684 a week, $35,568 per year, then they are no longer considered exempt in all likelihood, and we would have to pay overtime. So make sure that we are monitoring the minimum. We're not paying salaried employees less than what we're required to under federal DOL law. Also, if we have hourly employees, non-exempt employees who are working remotely, because all of us are encouraged to find remote jobs for our employees who can work at home. If they're hourly, we need to make sure that they are accurately and regularly, daily, keeping track of their time, and we have a protocol in place to review that time, make sure it's accurate, and our employees understand that if they are undertaking any work for us, that they are being paid for it and they are keeping track of all their compensable time. Okay. Now let's look at where a significant amount of questions exist in terms of our obligations and benefits under the Families First Corona Response Act. The nice acronym is FFCRA. This specifically requires a notice that all of us need to post that indicates what benefits exist under the FFCRA, and we need to have a very good fundamental understanding of the benefits provided under this act. There are two key provisions. Creates limited paid sick leave, generally 80 hours of paid sick leave for full-time employees. And the second benefit it creates is it amends the FMLA, the Family Medical Leave Act, to expand coverage for COVID-1 child care related reasons. Okay? The FMLA is only expanded for that one reason, child care related reason. We'll get into that in much more detail in a minute. So when people say, well, what benefits are provided under the FFCRA, the Families First, there are two. It creates opportunity for limited paid sick leave, and it creates an amendment to the FMLA that allows coverage for child care related reasons. The provisions of both the EPSL, emergency paid sick leave, and the expanded FMLA, the EFMLEA, are effective April 1st. They're not effective before then. There's no benefit gained before then by an employee under this act, and they will remain in place until December 31st, 2020, the end of the year. That's how it's written now. We'll see if it is extended, but that's the law presently. Okay. On April 1st, and this is very helpful, the DOL promulgated a temporary rule regarding both EPSL and EFMLEA leave and benefits that became effective on Monday. It's 120 pages, 123 pages actually, and it is very helpful in interpreting all of this. There is a link to it on the SDRA COVID page. We highly recommend that you review it. There's already been some pushback from certain senators in Congress about different aspects of it, and therefore the advice and guidance could change. But right now, this temporary rule is what we follow to interpret EPSL and EFMLEA. Try to say that 3 times in a row. Okay, let's start out with the EPSL. Okay? To get this paid leave, an employee must be an employee of a covered employer. A covered employer is a private entity with fewer than 500 employees, and there are certain public sector employers as well, but we're focused on the private entities with 500 or fewer employees. And for those of you that may be close in determining whether or not you have 500 employees, I would strongly suggest you seek a professional opinion before you assume it does not apply to you because you have more than 500. Meaning, make sure your count is accurate, because if it's found that you had fewer than 500 and did not provide the EPSL, you could face a variety of private causes of action and significant penalties. Okay? So, what are the rules here? Who qualifies for EPSL? On the next two slides, and they are slides as you access this PowerPoint down the road, and it will be provided to you. There are slides 30 and 31. These are the reasons that you can qualify if you are an employee for EPSL, provided you are an employee of a covered employer, 500 employees or less. First reason is you are subject to a quarantine or isolation order. Let's say you are a 66-year-old employee in Minnehaha County. You do not work for an essential employer, and therefore you are not allowed to go to work under the governor's order. That would be an example. Number two, you've been advised by a healthcare provider to self-quarantine. All right? Advised by a healthcare provider. That means there's a medical opinion. It isn't you saying, hey, I think I'm concerned about going to work. My niece, the nurse, told me I probably, shouldn't. They need a medical opinion, a note, okay? Number three, you are an employee experiencing symptoms of COVID-19, meaning coughing, sneezing, fever, and you are in the process of seeking a medical diagnosis. Let's say you have the symptoms, you were told to leave work, you are trying to get into a doctor who may be overwhelmed right now in terms of having enough time to see everyone, and it takes you 3 days to see the doctor. During that time period, you are seeking a medical diagnosis to determine whether you have COVID or COVID-related symptoms. That time period in seeking the medical diagnosis is protected. Okay, those are the first three. The next three reasons that provide a basis for EPSL leave is the employee is caring for an individual who needs to quarantine, isolate, or self-quarantine under government order or healthcare advisor advice. So it's got to be pursuant to the order, but for the order, or that you are having to care for someone who has been told to stay at home due to healthcare advice. Number two, the employee is caring for their son or daughter if the school or place of care of the son or daughter has been closed, or the child care provider of the son or daughter is unavailable due to COVID-19 precaution. If the child care provider simply closed up shop because they went bankrupt, or they decided they wanted to move to Arizona and not do childcare anymore, that is not a COVID-related reason. Having said that, if a childcare provider suddenly closes and it appears it is related to COVID, the concern about COVID, this is going to be generally broadly interpreted in the employee's favor. The third reason is the employee is experiencing any other substantially similar condition specified by the Secretary of Health and Human Services in consultation, etc. So if they are symptomatic and experiencing significant conditions, they may be eligible for this paid leave. So what does it entitle you to? Okay, what do you get if you qualify? If you're a full-time employee, defined as normally scheduled to work equal to or greater than 40 hours each work week, 80 hours of paid sick leave in total, not per qualifying events. Or if you're a part-time employee, you'd be entitled to the number of hours equal to the average number of hours such employee works over a 2-week period. That would be your extent of potential leave, meaning if I average 60 hours over a 2-week period, that would be the amount of leave I could be entitled to. And the third entitlement would be if I work a sporadic or varying schedule. At that point, I have to go into some very gymnastic-like calculations that are set forth in the order and regulations that I've referred to, that if we went over right now, we'd be out of time because they are very complex. But they are in the regulations, they are in that order I referenced, and you guys can do your own calculation. And obviously, if you need further advisement, don't hesitate to reach out. All right? Now, here's what the caps are. If the leave for employees' own COVID-19 qualified reason, that's numbers 1 through 3 on slide 30, you've been diagnosed, okay, that was the primary reason, you get as a benefit your regular rate of pay. And again, we're talking 80 hours if you're a full-time employee. The cap is a $5,011 per day and $5,110 aggregate. That's 511 times 10, 5 work days a week times 2 weeks, 80 hours. That's where that comes from. If you are taking paid leave pursuant to reasons 4 through 6, like we saw on slide 31, you're caring for a family member, you get 2/3 of your regular rate of pay, and the cap is $200 per day, $2,000 in the aggregate. That is how the 100% versus 2/3 is determined. For what reason are you out? Is it because of your own COVID condition, slide 30, reasons 1 through 3, or is it because you're caring for a qualifying COVID family member, reasons 4 through 6, seen on slide 31? Okay, let's go through a couple of scenarios, makes this all crystal clear, easy to understand, I say somewhat facetiously. Jessica takes 2 hours of EPSL to care for her son who is home from school. 2 weeks later, Jessica contracts COVID-19. Is she entitled to additional EPSL for her own illness under the FFCRA? And the answer is no. She may be entitled to leave under the FMLA, etc., or may have an ADA issue, but once the benefits are exhausted in terms of the EPSL, 80 total hours, that's it, okay? The prohibitions, additional prohibitions, and this is very important in terms of the EPSL, the paid leave, you cannot require, as an employer, you cannot require the employee to use other paid leave first. It's the employee's option. You cannot require the employee to find a replacement employee. And here's where we're going to have the litigation from all this down the road, is we cannot discharge, discipline, or discriminate against an employee who takes the leave or engages in similar protected activity. Meaning, we can't say, look, we have the leave, but if you take it and suddenly were trumping up reasons to get rid of you because we didn't like the fact that you did take advantage of it, that would be a discriminatory act that you could face significant exposure for in a wrongful discharge discrimination case. Okay, now let's go, in the interest of time, to our EFMLEA, which is simply an expansion of the FMLA into a very narrow category. If the employee is unable to work due to a need to care for the employee's son or daughter under 18, if the child's elementary or secondary school has been closed, or the child care provider is unavailable due to a health emergency, okay, then the employee can receive additional leave time. Now, unlike the FMLA, all that is required, we don't need the traditional FMLA employee eligibility requirement of being employed for 12 months, working at least 1,250 hours. Our employer has to have 50 employees within a set. We don't need any of that. All we have to do is be employed for at least 30 calendar days, okay, in order to be entitled to this benefit that we're going to describe in a minute. Remember, this is a caveat. Employees on furlough are not entitled to any of these FFCRA benefits, even if they were furloughed after April 1st. So as we evaluate furlough, be thinking of that, okay? And again, it only applies to private employers with 500 employees or less. It does not apply to healthcare providers or emergency responders as defined. We'll look at that definition in a minute. And this is where the law seems to provide relief, but they haven't really provided any regulations as how to qualify for the relief. That is, if you can show that we have fewer than 50 employees in our business, and that if we provide this leave, we jeopardize the viability of the business going forward, we can't afford to, and we can show financials illustrating, in essence, we're going to go under, there is a way to petition that this leave law does not apply to you. Of course, as we sit here today, there is no protocol set up as to what evidence would be necessary or where it would be submitted to, okay? The definition of healthcare provider in terms of being out from under, not subject to this act, is very broad, and it includes a variety of hospital, clinics, post-secondary nursing, EMT, retirement facilities, etc., or anyone employed by a company that contracts with these type of providers will find an exemption and not be subject to this act. Again, the definition is very broad, all right? The definition of emergency responder who would not be subject to this act is very broad, all right? Right now, in terms of those trying to get out from under it on the grounds it would cause viability issues, you'd go under because you could not afford to provide the paid leave or the EFML leave, simply says, don't send it in yet, but just compile any information that you believe would allow you to show it was not financially viable for you to provide it, which right now is not very helpful to those that think it doesn't apply because we would have to go under, all right? Now, what the EFMLA provides is basically the initial 2 weeks of unpaid leave. Your first 2 weeks, you get 10 weeks. First 2 weeks, if you took this emergency family leave to take care of your son or daughter for the reasons we've laid out, school's closed, child care provider is closed, would allow you to receive 2/3 of your available regular rate and it's capped at $200 a day, $10,000 per aggregate after the first 2 weeks. The first 2 weeks are unpaid. So that is this additional benefit for this narrow reason. Childcare. Schools closed, childcare providers closed. All right? Let's look at a scenario. Manny is working remotely. Manny's 12-year-old daughter's school and childcare are closed. Manny has requested EMFLEA leave for 2 days per week, in essence, intermittent to care for his daughter. Let's say his wife was going to care for her 3 days, he's going to take care of her 2 days. Must the employer allow Manny's leave request? And the answer is no, as the regulations are currently interpreted, and the guidance says you don't have to provide it in an intermittent fashion. You don't have to unless both the employer and the employee agree to provide it. Now, having said that, the best practice in all likelihood would be to work out an arrangement where we have achieved flexibility, met mutual needs, allow the person to continue working. But you do not have to you do not have to provide this leave intermittently unless you make a decision to agree to it on both sides, employer and employee, okay? Intermittent leave, both the EPSL and the EFMLEA may be taken intermittently, but only if the employer and the employee agree. We've talked about that. If it's on site, it may not be taken intermittently for reasons 1 through 4. Again, back to slides 30 and 31, provided there is work, all right? So leave for these reasons is intended in significant part to prevent the spread. So employees should not be present on the work site. This is significant. Remember, what we're trying to do here is be as flexible as possible to allow employees to work from home where they can and prevent the spread of this very contagious COVID. Now, having said all that, the DOL has been, I would say, facetiously gracious and said, we're not going to bring any enforcement actions against any public or private employers for violating the Act, the FFCRA, occurring March 18th through April 17th, provided that the employer has made reasonable good faith efforts to comply. So you do have what appears to be a grace period, provided you've been able to do the best you can to interpret and apply on this moving target law where the guidance either changes or hasn't been available in many instances until very recently. Basically, that grace period will expire, however, on April 17th. Telework. Frequent questions that we see are, to the extent the employee is able to telework in regard to paid leave and EFMLEA leave, if there are teleworking opportunities and the person is caring for their child at home, in essence, and they're able to both work and care for the child, these benefits are not available. But if the employee cannot telework because it's too hard to do both, they are entitled to benefits. Now, those of us that are somewhat cynical would say, the employee may go, hey, I'm the only caregiver here. I can't do two things at once. I'm entitled to these leave benefits, paid leave benefits, because I can't do both. And the inquiry will be, well, was there another parent or guardian that could have watched the children? Were there other reasonable alternatives available that would have allowed you to work? That will be the test. Remember this, teleworking, intermittent leave while teleworking as well is available only with employer agreement. The employer can agree to allow work during regular hours with some hours as paid leave or allow alternative hours to do a full day's work. Meaning, well, Maybe you can do your job from 2 to 10, if we can somehow work that out from a business perspective, which would allow you to watch your kids, and then when your parent, significant other caregiver would arrive and be able to watch the kids after that. So there are opportunities here to provide alternatives to intermittent leave during teleworking. Okay? Now, obligations under FFCRA during slowdown, furlough, or temporary closing. An employee is not entitled to take EPSL or EFM-LEA leave if employee is furloughed due to lack of work. If there's lack of work, they do not get this leave opportunity. Slowdown and reduced hours. If an employee's hours are reduced due to lack of a work, employee may not use EPSL or EFM-LEA leave for hours that she is no longer scheduled to work, but may take leave if unable to work scheduled hours due to the COVID. So that is significant when we are interpreting furloughs, all right? Now, let's talk a little bit about employment insurance expansion. Yesterday, our South Dakota Department of Labor issued a press release saying that they will now provide the additional 600 week per worker under the CARE Act beginning the week of March 29th for people making unemployment claims. In the press release, the Department of Labor indicated, South Dakota Department of Labor indicated that claimants do not need to separately request the FPUC, that's the Federal Pandemic Unemployment Compensation, the extra $600 benefit, but should continue to file a regular weekly request for payment. The additional 600 weekly payment will be paid within the regular weekly payment via the method selected by the claimant rather. Okay, so this CARE Act additional $600 weekly benefit for those on unemployment is available as memorialized yesterday through this press release from our South Dakota Department of Labor. Individuals are not eligible if they are able to work remotely. They are receiving paid sick or paid family leave benefits under the FFCRA, or their salary has been reduced but regular work hours remains the same. So remember, this extra $600 a week benefit is now available through our South Dakota Department of Labor unemployment insurance. Okay? Now, as we go to the next slide, in terms of expansion, there are a number of bullets indicating points here indicating the reason under our unemployment insurance that an individual will be eligible to receive benefits. And rather than read all those to you, I think you can see that it is very significant in terms of how broad it is, in terms of how general it is. And so if you have employees that have been laid off or furloughed related to a COVID-19 issue, that they need to be directed to our South Dakota Department of Labor to apply for these unemployment benefits, because the opportunity for South Dakota benefits and the $600 additional CARE unemployment, $600 per week CARES unemployment benefit is significant, and the definitions are very employee friendly and receptive. Okay? Question: what if I have an employee who chooses not to work due to fear and anxiety? Are they entitled to unemployment benefits? And the answer is Probably not, unless their fear or anxiety is accompanied by some type of medical or mental health provider indicating that they could not work from a professional perspective due to that COVID-related anxiety. Absent that, in all likelihood, they would not be able to receive benefits. Okay? Remember, as I'm going through my notes, that our South Dakota Department of Labor has a couple of excellent resources that every employer, small employer, should review, and they have a COVID page that walks through different scenarios that is very helpful in terms of who is eligible, what employees have to do to apply, what reasons, COVID-related reasons, allow them to receive benefits, what the CARES extra $600 benefit is. Highly recommend you review that South Dakota Department of Labor COVID page and all the different Q&As that interpret it. Both employers and employees should be directed to that specific page. Now, as we move through our schedule, the Paycheck Protection Program, the loans that are now available to small employers of fewer than 500 employees, I would think many of the people on this call have applied for these. And I would recommend, even though you may have to wait in line to fill out an application, but get with your lender, get your application in, because absent additional money being directed towards this program, it's amazing how many applications are already in, and you want to take advantage of it if you can at all costs. This loan, which became available for small businesses on April 3rd and will become available April 10th for independent contractors and self-employed individuals, is 100% guaranteed. You can take loan amounts of up to $10 million per eligible entity. These loans have a 2-year maturity. There is significant loan forgiveness that we will discuss if an employer maintains their payroll to pre-COVID crisis levels. Loan payments are not due for a 6-month deferment period after you receive them. Interest will accrue, however. The interest rate is 1%. Initially, it was going to be 0.5%, but they changed it to 1%, I think, to make it worth the bank's time. And there is no recourse. The Small Business Association has no recourse against individuals, shareholders, members, or partners, or loan recipients for non-payment unless the loan dollars are used for impermissible purposes, which means if you follow their rules, they don't have recourse against you if, heaven forbid, you can't pay it back, provided you use the funds in a way that was and is prescribed, okay? The small business is defined as 500 or less, and there are other eligibility rules as well. It also applies to general 501c entities, and in some cases applies to tribal entities as well. All right. Ineligible entities include household employers of nannies, etc., life insurance companies, businesses located in a foreign country, private clubs, businesses who derive more than 1/3 of their gross revenue from gambling, businesses primarily engaged in political or lobbying exercises. All right. The application process, it's called SBA Form 2483. It requires just general basic identification information, a list of all owners who have a 20% or greater ownership stake, any businesses under common ownership or management with the applicant, good faith certification by a business representative that the reason for the loan is COVID related. As I understand it, there's not going to be a whole lot of underwriting for these loans because that would slow the process down. Therefore, if you simply in good faith sign that your loan is for COVID-related reasons as defined in the application, that will allow the process to go forward. I have talked to many members that have already been approved for these loans, and many of you may be on the line. And these loans right now are being withheld by the banks until they get a better understanding of the protocol for releasing them. But they are already approved, and they're just waiting for further guidance that should come in the next couple of days, according to the banks, so that the funds can be released. Okay? Now, remember, these loans are capped at $10 million or 250% of average monthly payroll costs during the last 12 months. We're thinking that's going to be all of 2019 when you look at the look-back period. The use for the loans can be group health care, mortgage interest, payroll costs, interest on other defined obligations, rent and utilities, etc. The opportunity to have forgiveness of this loan is very significant, okay? In that you can receive forgiveness of the amount capped at the principal amount of the loan plus any accrued interest is the sum of the following, which was incurred and paid within 8 weeks of your loan origination. So you have an 8-week period where this forgiveness amount will be determined. I understand loan origination, that's the date it starts as to when you receive your funds, and you can be forgiven for payroll costs, which include interest on mortgage obligations incurred on or before February 15th, 2020, payroll costs plus interest on mortgage obligations plus rent obligations plus utility payments as defined in this loan, and the loan hasn't been used for more than 25% of non-payroll costs, that you can receive the opportunity for forgiveness. Now, obviously, we could do 3 hours on all the ins and outs of forgiveness, but understand this. You have to apply separately for forgiveness, and you are using this 8-week period in which to determine the amount of the loan that you will be forgiven, and you will be incented significantly because you'll only get forgiven if you bring your payroll back to pre-crisis levels, i.e. you're bringing people back to work. At that point, those, as long as it's 75% payroll costs that you're seeking forgiveness for, and 25% or less of non-payroll costs, much of that can be forgiven. Now, obviously, there are a number of other restrictions on forgiveness. I was talking to a member today who knew all of this in and out. He was simply waiting for his loan to be released. But all of you who are seeking this must, one, become very familiar with the application process, and very, very familiar with the forgiveness application. And you're going to have to do that in short order because you have the opportunity to get a significant part of this loan forgiven if you simply bring back employees, and the great majority, 75% of what you're seeking forgiveness for is related to payroll. So it appears to be an excellent opportunity underwritten by the federal government without recourse, without need to do underwriting, without personal guarantee that all of you should be pursuing. Now, finally, there is also opportunity for tax credits as defined on this PowerPoint slide. Remember this, though, much of the tax credits that are available may not be available if you take out a paycheck protection loan. And you need to make sure that you evaluate what your financials are in terms of whether you took the loan or not, because it appears you will not be able to get that tax credit. Again, to get the tax credit, as you review the IRS regulations, there is an excellent roadmap that is provided throughout Jackson Lewis resources as well as SDRA resources to make sure that you're seeking tax credits in the proper way. But don't forget your tax credits, the opportunity to get them may not exist if you take out a paycheck protection loan. Okay? Also, in regard to all the material we're discussing, it is definitely an evolving target. We're doing the best to provide you solid advice, but the guidance in many instances changes. Therefore, we put up this disclaimer that says, make sure that you are double checking your own advice, but this is the way we interpret and seek and provide advice based on what we're seeing evolving on a daily and weekly basis regarding all of this information. It is now 3:45, and I think we've covered the great majority of questions today. So without belaboring this any further, with permission from Nathan, I really think we've covered all the questions. We've hit the highlights, and naturally, if anybody has further questions and would like to pursue them with the SDRA or simply pursue them through the retainer, be happy to take those. And with that, and taking only my second breath of the hour and 45 minutes, I'll turn it back over to Nathan.
Thanks, Chris. Really appreciate it. We have had a couple of questions come in. Please check out SDRA.org or the Jackson Lewis website to get some of those answered. One of the questions was related to signage for the Families First Coronavirus Response Act. If you go to SDRA.org under Workplace and Employees, we have the signage right there available at a link. Whether you are required to post it or not is an open question that will depend on your business. You don't actually have to post it. You can email it out or post it on your website, that kind of thing. So you can meet those provisions relatively easily. So we just encourage some employers who have those types of questions, visit SDRA.org. Again, the webinar has been recorded. And we are going to send out an email. It might be a little while, so don't look for it immediately, but we will absolutely send out a recording of the webinar once we get it formatted and uploaded. Again, on SDRA.org, there's a variety of frequently asked question pages, other webinars. Chris mentioned the Jackson Lewis daily updates. Those things are excellent. So thanks for your time today. Thanks again to Chris, and we'll look forward to being in touch again. Thanks and take care.